She worked administrative shifts for 11 to 16 hours, but she was only paid for 8. Her settlement check came to $1,065. Intel makes the chips inside of the computers, servers, and data centers, which run most of the internet. Between 2009 and 2025, they also generated 20 verified legal and regulatory actions across 5 different countries and at least 4 different federal agencies. This video covers Intel Corporation. Everything you're about to hear comes from a court filing, a government agency record, or an official settlement document. There's no personal opinion here, there's no allegation without a citation, there's no hearsay. The full sources for everything can be found at evilcorporations.com. In November 2017, Intel's CEO sold approximately $39 million in company stock. 2 U.S. senators formally asked the SEC and the DOJ to investigate the action. Neither agency has ever said what happened next. In summer of 2018, Intel received 2 internal reports about a security flaw in its chips. The company acknowledged receiving these reports, but the flaw wasn't publicly disclosed until August 2023. What happened between those 2 dates has never ever appeared in any public document. I return to both of these stories later. An administrative assistant in California regularly worked shifts of 11 to 16 hours. Her employer logged her time at just 8 hours per day, and she wasn't paid for the rest of the workday. When she filed a lawsuit, Intel settled for a total of $5 million across the whole class of the lawsuit plaintiffs, who here are the employees who got wage thefted. This woman's share of the settlement was a mere $1,065.84. The same logic that underpaid an hourly worker was also applied separately to tens of thousands of Intel engineers. Between roughly 2005 and 2009, Intel was a group of 7 major Silicon Valley companies. The others included Apple, Google, and Adobe. These companies all had private agreements with each other to not recruit each other's engineers. There would be no code calls and there would be no competing job offers. The Department of Justice opened an antitrust investigation, and all 7 of these companies signed consent decrees in 2010. Former employees then filed a class action lawsuit covering approximately 65,000 current and former technical workers. The class action argued that these colluding agreements suppressed the workers' wages by between 10 to 15% below what the market would have paid otherwise. In September 2015, there was an approved settlement of $415 million covering Intel, Apple, Google, and Adobe. An earlier $324 million settlement had been rejected by the court for being too low. The shitty wage practices were visible, but the chip market practices were not. Between roughly 2002 and 2007, Intel paid computer manufacturers directly. The payments went to Acer, Lenovo, and HP. The condition of the transactions was quite forward. It was to delay, limit, or cancel any computers built on their rivals' AMD chips. The European Commission called these, quote, naked restrictions. That phrase means that there's absolutely no business justification offered. Intel was simply paying their rivals' customers to avoid buying from their rivals. As a result, a customer shopping for Intel in 2004 at a major retailer would have been able to find an AMD machine from HP, Acer, or Lenovo, regardless of what AMD actually had available. And this wasn't because the products didn't exist, because they most certainly did exist. I used to have one of those computers. But it was solely because Intel had paid the manufacturer to keep them off of the retail shelf. In 2009, the European Commission fined Intel 1.06 billion euros. It was, at the time, the largest antitrust that the EU had ever issued. The EU found a different version of the same corporate misconduct in Intel's rebate program running in parallel, which was that Intel was also running a separate program alongside the direct payments. Major computer makers, including Dell, HP, and NEC, received private rebates from Intel. The rebates were conditional. The conditions were to buy all or nearly all of their chips from Intel, and the payment would continue. Conversely, if they started buying even a small percentage of their chips from AMD, then the payments would stop. Dell personally received hundreds of millions of dollars from Intel during this period because of these rebates. These rebates were never disclosed publicly. They were private financial arrangements that made it economically irrational for manufacturers to diversify. The European Commission counted this as part of the same 1.06 billion euro fine that I was talking about a moment ago. On an appeal in 2022, the EU General Court overturned this portion of the fine specifically. The court ruled that the Commission hadn't completed the required competitive harm analysis. The ruling didn't find that there wasn't any corporate misconduct, but rather it had found that the Commission's proof of harm was legally incomplete. Because of this, in 2023, the Commission re-fined Intel 376 million euros on the confirmed portion. In December 2025, the General Court reduced that further to a mere 237 million euros. This same pattern of corporate misconduct, a business decision made internally and disclosed only when forced, connects directly to Intel's chip manufacturing history. Intel paid AMD $1.25 billion to make the antitrust litigation disappear. That's a number that's worth stating plainly. On November 12, 2009, Intel and AMD settled every single outstanding legal dispute between them. Intel paid AMD $1.25 billion in cash, and Intel also agreed to a set of business rules that prohibited certain exclusive dealing arrangements. Both companies signed a new 5-year patent agreement, and notably, Intel didn't admit to any wrongdoing. The antitrust enforcement was spread across multiple regulatory agencies. Each separate agency reached approximately the same conclusion regarding Intel's corporate misconduct. On December 16, 2009, the FTC filed a formal complaint against Intel under federal law. The legal complaint covered 3 separate categories of misconduct. First was the payments to computer makers conditioned on limiting purchases from AMD. I covered that above. Second was the loyalty rebates that function as financial penalties for buying from competitors. This I also covered earlier. But third is the one I haven't documented publicly before. Intel had deliberately engineered its compiler software to run programs slower while on AMD processors. A compiler is a software that developers use to convert the code that they write into instructions that a computer chip can't execute. Intel's compiler was widely used across the software industry. The FTC alleged that Intel had designed that compiler so programs would run noticeably worse on AMD hardware than on Intel hardware, even when the AMD chip was technically capable of achieving better performance. It's a deliberate choice to kneecap their competitor, because a developer using Intel's standard tools would produce software that ran well on Intel, but ran worse on their competitor's hardware, regardless of that actual hardware capability. Intel signed a consent order in August 2010. That order required Intel to make disclosures about its compiler software and place restrictions on its marketing and pricing activities for 10 years. Intel, again, didn't admit to any of the violations. Now, in Intel's defense, the New York Attorney General's 2009 antitrust case against Intel was subsequently narrowed by a federal judge in December 2011, with triple damages barred. The final settlement of the $6.5 million was described explicitly as covering the Attorney General's legal costs, not for any findings of liabilities on Intel's end. Intel's legal challenges to the EU's rebate theory ultimately resulted in that portion of the fine being overturned that I mentioned earlier. And in the OFCCP pay discrimination matter, Intel voluntarily entered an early resolution agreement before being formally cited, which the Department of Labor's regional director specifically noted as being proactive conduct. And so the antitrust and competitive misconduct record is one thread, but the second thread is what Intel knew about its own products and when. In June 2017, researchers from Google's Project Zero team notified Intel of a fundamental flaw in the design of its chip. This flaw affected every single Intel processor made since roughly 1995. It allowed an attacker to read sensitive data directly from the memory of any Intel-powered devices. This includes passwords, encryption keys, personal files, all of that kind of stuff. Intel kept this information from the public for 7 months. During those 7 months, the 2017 holiday shopping season occurred. Millions of Intel-powered devices were sold to customers who had no knowledge of this flaw. In July 2018, the vulnerabilities were publicly named Meltdown and Spectre. The patch that Intel released to address Meltdown caused the computers to run measurably slower for certain tasks. Spectre, the more serious vulnerability of the two, had no complete fix, which means every single device that Intel sold between June and December 2017 came with a flaw that its makers already knew about. A consolidated class action lawsuit alleges that Intel sold these defective products, well, yes, being aware of the defect, but also that the available remedies either left users vulnerable or reduced the performances on the devices that they had paid for. 5 years after Meltdown and Spectre, the same pattern appeared with a different flaw. According to a 112-page class action complaint filed in November 2023, Intel received 2 internal reports in the summer of 2018 identifying a separate vulnerability in its chips. That vulnerability is now called Downfall. It affects Intel chips from the 6th through the 11th generations, which covers the large majority of Intel consumer processors sold between the years 2015 and 2021. Downfall allows an attacker to read the data from other programs running on the same processor. These are, again, stuff like passwords and encryption keys. The legal complaint states that Intel acknowledged both the internal reports, but that Intel also didn't fix a hardware flaw in subsequent chip generations. A Google engineer named Daniel independently discovered the same vulnerability in August 2022 4 years later and reported it to Intel. But Intel asked him to keep it confidential until August 2023, a whole year later. The only available fix is a software patch that also reduces the performance of their chips by up to 50% for common tasks like encryption, gaming, and video editing. This lawsuit alleges billions of processors were sold during that 5-year window between Intel's initial notice and the public disclosure. Pat Gelsinger became Intel's CEO in March 2021, and he held that position until December 2024. The downfall vulnerability was publicly disclosed in August 2023. During his tenure. The foundry's decision's financial losses were reorganized to become visible to investors in April 2024. Also during his tenure. Both of these disclosures followed periods of public optimism from Intel's leadership about the health of its products and business units. And so the chip security disclosures were one version of the pattern, and the investor disclosures were another. In June 2017, Intel CEO Brian Krzanich learned about Meltdown and Spectre. On December 30th, 2017, 5 months after that discovery, he set up a formal stock selling schedule. This is a pre-arranged selling program that executives use to demonstrate trades were planned in advance. On November 29th, 2017, he executed that plan. He sold 889,878 shares and stock options worth approximately $39 million in proceeds, netting roughly $24 to $25 million in profit. After that sale, he held exactly 250,000 Intel shares. That's coincidentally the minimum number that the Intel's corporate rules required him to hold. Intel announced Meltdown and Spectre vulnerabilities publicly in January 2018. Intel stock obviously declined after that investment. The United States Senators Jack Reed and John Kennedy sent a formal letter to both the SEC and the DOJ requesting an investigation, citing concerns about potential insider trading. Intel responded by claiming that the sale was pre-planned and unrelated to the security discoveries. I don't know who's gullible enough to believe that, but it's a defense that their high-priced lawyers went for. Intel's corporate values include the word transparency. That word doesn't appear in any of the enforcement documents, settlement agreements, or findings of this research set. The SEC and the DOJ received a formal request to investigate Intel's CEO's stock sale. But despite Intel's supposed commitment to transparency, their public record ends there, with no mention of what their findings are. Intel's 13th and 14th generation desktop processors sold from late 2022 through 2024 contain a flaw in the chip's clock tree circuit. Combined with a bug in Intel's own firmware, the chips would require more power from the motherboard than what they were designed to handle. This caused system crashes, instability, and in many cases, permanent physical damage to the chip that couldn't be undone by any software update. Intel acknowledged the problem publicly in July 2024 under the name vmin shift instability. In September 2024, Intel released a patch to prevent future damage. But since the damage was all physically done to those chips, Intel confirmed that this new patch could not repair the chips that had already been damaged, which is very cool and very good. In November 2024, a man from New York filed a class action lawsuit against Intel, alleging that the company knew about the defect by late 2022, but still continued marketing the chips as being high-performance products. The security flaws and product defects were only disclosed when external pressures or external discovery forced that disclosure. The financial picture follows the same pattern. In early 2024, Intel reorganized its chip manufacturing business into a separate division called Intel Foundry. I mentioned this earlier. And they began reporting its financial results separately for the first time. On April 2nd, 2024, Intel disclosed that the Foundry division had lost $7 billion on $18.9 billion of revenue in 2023 alone. Intel's stock fell 8.2% that day. 3 weeks later, Intel reported that Foundry revenue had declined 10% year over year. The stock fell by another 9.2%. In August 2024, Intel suspended its quarterly dividend and announced layoffs of over 15,000 workers. The market value fell more than $32 billion in a single day. A shareholder class action lawsuit filed that year alleges that the CEO, Pat Gelsinger, and the company's CFO, a man named David, had made false and misleading statements about the Foundry business's health, including references to, quote, significant traction and growing demand. The court dismissed the complaint in early 2025. Ruling that the CEO's statements refer to specific customer engagements rather than the overall financial health of the company and the division, and therefore didn't meet the legal standards for securities fraud. The court did, however, allow the lawsuit's plaintiffs, those are people doing the suing, to file an amended complaint. That process is still ongoing. Intel told investors at its 2019 analyst conference that its next generation 7nm chips would ship in 2021. On July 23, 2020, after the trading markets closed, Intel disclosed a manufacturing defect in its 7nm process. This defect would delay the product by at least 6 months. The Intel stock fell more than 10% in the after-hours trading that night. The total decline when the dust settled was more than 16%. Erasing approximately $43 billion in market value. Investor Cheryl Huang had purchased 4,100 Intel shares worth approximately $285,000 on July 22nd and 23rd, the days immediately before and during the announcement. Shareholder lawsuit alleged that the management of the company had made repeated public statements of confidence in the 7nm timeline at the April 2020 earnings calls without disclosing a defect that they had already known about internally. So across the 20 verified controversies in this document set, the total and confirmed publicly documented financial penalties and settlements is as follows. The AMD settlement is $1.25 billion. The EU reduced fine as of December 2025 is 237 million euros. The FTC consent order had no monetary penalty. The high-tech employee settlement was $415 million spread across those 4 companies, and we don't know what Intel's share of that fine was because that individual portion was never publicly itemized. The OFCCP pay discrimination settlement was $5 million. The California wage settlement was also another $5 million. The New York Attorney General settlement was $6.5 million. That total, for the confirmed monetary figures attributable directly to Intel, exceeds $1.5 billion with the B. That number excludes the original 1.06 billion euro EU fine, which was partially overturned. It excludes confidential settlements, it excludes pending litigation, and it obviously excludes the non-monetary penalties, and it also excludes the losses borne by Intel's investors during the multiple disclosure events. The single greatest behavior pattern across this document set is this. Intel has repeatedly possessed material information about the performance, safety, or financial condition of its products and business units, and disclose that information only when compelled to do so by external investigation, litigation, or independent discovery. That pattern appears across 6 separate controversies, including chip security vulnerabilities, manufacturing defects, and financial reporting. It spans 3 separate regulatory proceedings, 2 separate investor class action lawsuits, and at least 2 independent external discoveries of information that Intel already held internally. It appears across the tenure of at least 2 separate CEOs. What Intel's internal engineering records show about the decision not to fix the downfall hardware flaw in chip generations released between 2018 and 2022, after Intel acknowledged receiving those internal reports about the vulnerability. None of that has appeared in any public filing, court document, or regulatory record viewed for this investigation, and I was very thorough in my research. The factual question that the evidence raises but doesn't answer is this. At what organizational level and by what internal process were the decisions made to continue releasing products after material vulnerabilities or defects were disclosed and identified internally? And who signed off on the disclosure timelines? That question appears between the lines in the underlying litigation across multiple cases, and it wasn't answered in any publicly available document that I could find. I am not saying that Intel is a criminal enterprise. I am saying that these are the legal documents and this is what they show. The full source table for every document set in this video is at evilcorporations.com and also down below in the description box. Every single case number, every agency docket, and every SEC filing is listed with a direct link. In the next video, I'll run the same process in a company which is all over the news cycle last year for allegedly being woke, but under its curated progressive image lays a much darker reality. So make sure to subscribe to watch the video when it comes out.